Mr. Woods is here today after failing to appear before referee Couteau on October 6, 2023. Bond is currently set at $500. This is the 9th bench warrant. I do not have any employment information. The last payment made on this account was in May of 2023. Front of the court recommends that a reasonable bond be set on this matter and it be scheduled for hearing on November 1st, 2023 at 8:45 a.m. before this court.
Mr. Woods, you're before the court charged with civil contempt of court due to your failure to appear at a prior hearing as a result of your failure to pay child support. The purpose of this hearing is to set a bond that would assure your tenants at the next hearing on November 1, 2023 at 8:45 a.m. You will get notice of that in writing. Are you working, sir?
Yes, I am. I'm working in Indiana. They came and got me from Indiana. I came down for another charge and they just popped this one up. I changed my address in the courts and everything. I sent them mail, sent them my address and everything in the mail, and I never received any paperwork on this.
Okay, what happens if you change your address with the court? That doesn't change it with the friend of the court. You have to go to the friend of the court's office or send them something.
I sent it to child support because I got paperwork for the child support for my food stamp card down in Indiana. Okay. So I got it sent. They sent me the paperwork to my house from the child support saying my child support and stuff, so I can give it to the food stamp office.
Okay.
I got that, but I didn't get anything from court cases.
Okay. What you could have received is on the support. You could have received something from Lansing, as opposed to the Calhoun County friend of the court. So when you get out, you're going to have to go to the front of the court's office in the basement of the building of the Hall of Justice and fill out the form with your new address. Unfortunately, there's a lot of moving parts here and they don't speak to each other. So you're going to have to make sure that you do it with each of those entities.
All right, I got that understood now, sir. I didn't know. I was like, why would I have? I said I haven't received anything. I received everything else, but I understand it now. I filled out paperwork downstairs earlier today. Okay. Giving them my new address and everything, and my employment and all that.
Are you able to post a bond, sir?
I know $500.
Okay.
I got $100 in my checking account. I can use that probably, and I got a card to cash that out with if I go down there.
Okay. Well,
I got a job and everything.
Yeah.
My check is waiting for me in Indiana. Like I'm supposed to get paid on Tuesday. This Tuesday just passed, and now I'm stuck here and I can't get to my check. I got a little bit in my checking account, and I got some in my account too. I didn't have to put my account from the other county. I had a check for $395. I didn't have them put it in the account because I didn't want them to take it for what I owed due to the last stuff, so I could use it for child support. So I have some money. So if I can have $100 bond, it would be able to give me back to work, get you your money and everything else also.
Okay. Well, what I'm going to do is I am going to give you a break, even though it's your ninth bench warrant. I'm going to set your bond in the amount of $100. And I will tell you before the November 1 hearing, you should make your payments. And if you don't, there's a chance that you'll go to jail in November. You understand?
All right. So like what, $50 or $25? What? How much do I owe?
I don't know. I don't know what the amount is. But I'll tell you, you haven't paid since May of this year, so you probably owe quite a bit.
No, I only owe. They're grown now. They're grown. It's only for arrears. We set up a program to forgive the arrears program. Everything's supposed to be swiped out.
Okay, well, it's not, so you'll have to check into that too. But just because they're adults doesn't mean that the arrearage goes away. You still have to.
I paid, but I've been paying every time for the arrears, and it was like $1,200 like 5 times ago. And every time I get it arrested, they take my money. Okay. I'll figure out when I get out. I'll go down there.
Yep. Okay. Good. Go ahead and do that then, and you're excused. Have a good day.
Is it $100 PR bond or $100 cash bond?
$100 cash bond.
All right, I'll say with a PR bond, it'd be a lot better. That way I could pay my way to get back home, and then I'll be able to pay on them too.
It might be better, but we wouldn't get any money then. So
you would. I'll go down there and give it to them as soon as I get out today. I promise I will.
It's a cash bond, sir. So
all right, that's fine. You already did it.
Okay, thank you. You're excused. Court will note filed by Ms. Podolsky. It's a renotice of plaintiff's notice of entry of default order.
Thank you, Your Honor. This was not a divorce, simply an initial DC case. The defendant was defaulted. He did not participate in any of the proceedings.
Ms. Podolsky, you're going to have to break up your sentences so we can interpret.
I apologize. I'm sorry. He did not file an answer and a default was entered. That is when our order was first noticed for entry before the court. In the mail over the weekend, I received an answer to motion regarding support. There also appears to be an answer to the complaint for custody. However, there is no motion to set aside the default. In his answer, the defendant admits that he was gone for several years when he was deported to Mexico. In his answer, it appears defendant is upset about the amount of support that he is ordered to pay. Defendant indicates his work is seasonal, only working 7 months of the year, unemployed 5 months of the year. But clearly defendant is able-bodied and can work full-time 12 months of the year. We are asking the court to enter the judgment today. This awards legal and physical custody to the plaintiff mother and parenting time at all times and places at which the parties can agree. Defendant's actual income was used to calculate support. It was based on him working 12 months of the year, not 7. This order aligns with the custom and practice of the parties and is in the best interest of the minor children. And we are asking the court to sign it today. Thank you.
Gracias.
Mr. Maldonado, what is your response?
I only responded to the motion because I didn't agree with what she presented. I don't think she should have the custody because she only has a permit to work here in the United States, and in any moment she can be deported. I am a legal resident, and anything that happened to her, I would be responsible and I will take care of my kids.
La custodia porque es bien para ellos, se la doy.
I agree with the judgment of the judge for the best interest of the kids in custody, in whatever the judge deems proper.
Mr. Maldonado, what is your income?
I make $18 an hour.
Baja el trabajo.
During the summer, I work between 60 and 70 hours a week. But now that we're in the fall, the work load is much less.
Varía las horas.
When it rains, we don't work and things vary.
Okay. Thank you, sir.
Gracias.
Is there anything else you'd like to say?
No, es todo.
No, that's all.
Okay, thank you.
Gracias.
Well, the court has heard the response in this particular matter. It does appear that Ms. Podolsky has filed the matter appropriately. And the defendant has not stated any reason that he could not work full time. As a result, the court will enter the orders as submitted by Ms. Podolsky. Mr. Maldonado, if your circumstances change, you have a right to petition the court at any time for a support review. So the court will enter the order.
La corte entrará la orden.
And that will conclude this matter at 9:09 a.m.
Y esto concluye este asunto a las
Court will note the
9:09 de
appearance
la
of Ms.
mañana.
Podolsky on behalf of plaintiff, Mr. Todd on behalf of defendant. This matter is before the court on the plaintiff's motion for counseling and other relief. Ms. Podolsky, have you received Mr. Todd's answer?
Yes.
And it looks like that Mr. Todd and the defendant are not disagreeing or they agree to participate in counseling if the plaintiff does, and agree to our family wizard as well. Is that what you take?
That is my understanding. Yes, so we have an agreement on our family wizard. I guess I would just state as it relates to the counseling, my client already does participate with the counselor at the counselor's discretion. At this point, what we're looking for is for dad to engage in that counseling due to the anxiety and the emotions the minor child is feeling. So we would just ask that any order, if it were to be about family counseling, to be at the counselor's discretion. We believe that this is important for the parent-child relationship.
Mr. Todd, do you have any issues with that?
No, Your Honor, I think that's appropriate. We just want everybody to participate as well.
The court would order that, again, that both of the parties would participate with the child's counselor as deemed appropriate and proper by the counselor, as well as utilize our family wizard. I do know that there is some issue as it relates to the prescription medication. Court would only order in that regard that both parties would administer prescribed medications that is not in conflict with any other doctors. If there is a conflict, then we're going to have to have the doctors discuss with each other as to again, any particular issues to resolve that issue.
Okay.
That take care of your issue there, Ms. Podolsky?
I think it does. I think the concern was that if dad, after reading the motion, if dad had the minor child see another physician, the plaintiff was not informed of it. She was informed of an appointment this afternoon. She will be present at that appointment. And if, I guess, as the court said, if there are conflicting instructions, the physicians can speak. And if we need to, we can come back to the court.
That's fine. Okay, Ms. Podolsky, I'll ask that you would prepare that order and submit under a 7-day notice.
Thank you.
Thank you all. You're free to go. Have a good day.
Thank you, Your Honor.
Hello.
Hello, your first and last name, please.
First name is Danny. My last name is Iron.
Court will note the appearance of Ms. Podolsky on behalf of defendant. This matter is before the court on the defendant's motion regarding counseling and other relief. Ms. Podolsky.
Thank you, Your Honor. As we stated in our motion, there are several concerns in this matter. One, we're asking that the parties be ordered to communicate using our family wizard. There has been a series of harassing phone calls, embarrassing phone calls at places of employment, swearing, verbal attacks, racial slurs. So we think at this point, our family wizard should be the only form of communication between these parties. Further, we do believe that there is a need for counseling between father and the minor child. It has come to the point where the minor child has such anxiety that he's experiencing abdominal issues about going to parenting time. He is yelled at. He is called soft and emotional when he gets upset. He's not receiving assistance with homework at dad's home. He's yelled at for holding up family time when he's trying to work on his schoolwork. After the filing of this motion, he came home from dad's house with all of his belongings. He was told that he wasn't to live there anymore and not to come back. This was done verbally. This was also done in writing. And then dad flip-flopped and said, "I love you so much. You're my son." I mean, this is at this point emotional whiplash for this minor child. And then last night, the minor child left a message for my client that he was asked to create a video for the court where he was told to lie, and he was afraid that this court would find out that he's lying. This is completely inappropriate. We believe at this point that counseling is absolutely necessary between the defendant and the minor child. Speaking to the minor child about the court case, having him record videos is wholly inappropriate, and it needs to stop immediately. So we're asking the court today to order our family wizard for the communication piece and counseling between the father and the minor child. Further, we've got concerns that the minor child's means of communication with the mother during parenting time are being impacted. And so we're asking that the minor child continue to have his access to the cell phone when he's with both parents for communication.
Okay. Mr. Irons, what's your response?
My response is I would like to seek legal representation because I'm not legally represented right now. So I ask of you to please postpone this so I can get an attorney. And at the same time, I ask of you to speak to the child and not go off a hearsay, because this is all what she's saying the child stated. So if the child stated all this, then I ask of you to speak with him as a one-on-one conversation and find out if this is what the child said and not just the parent.
Okay. Well, what I'll do, sir, is because you want representation, I'll give you that opportunity. We'll adjourn the matter adjourn it for 2 weeks to get, so you can get to an attorney. I will not speak to the child. I'm only permitted to speak to the child in custody cases when the court has to discern the preference of the child. I'm not able to, and I cannot speak to a child as to disputed matters. So I will not do that. So we'll put it over for 2 weeks to allow Mr. Irons to get representation, then we'll proceed at that time.
Can I have one other question, Your Honor?
Sure.
Am I allowed to have a jury trial?
No, there's no jury trials in domestic cases.
Okay.
Okay. Ms. Irons, you can talk to your attorney and then she can relate it. As long as you're represented, you need to speak to her.
Kelly,
Okay, I appreciate
you'll have to call me after the court hearing, okay? Okay.
Okay, thank you all. We'll end this matter at 9:20 a.m. You're free to go and we'll see you back in a couple of weeks.
Thank you.
Thank you.
Good morning.
Good morning.
Attorney Schaefer, is your client present? Yes.
Yep.
Calling.
Court will note the appearance of Mr. Schaefer on behalf of plaintiff, Mr. Umlauf on behalf of defendant. We have two motions before the court, defendant's motion for change of venue and plaintiff's motion for change in custody. I want to address the change of venue first in this particular matter. Mr. Umlauf claims that this action should have been filed in Tuscola County. And Mr. Umlauf under MCL 722.26(2), it states that if the circuit court of this state does not have proper continuing jurisdiction over a child, that you may be able to do that. But obviously, plaintiff filed their matter 7 days before you in Calhoun County prior to you filing in the other counties. So why would Calhoun County not be the proper jurisdiction?
Your Honor, because at the time of the filing of the plaintiff's complaint, the minor child was not residing in Calhoun County. The child in this situation was born on September the 19th of this year. On September the 22nd, my client left the marital home with the minor child and moved in with her parents in Tuscola County in Cairo, Michigan specifically. The plaintiff, was aware of that, was aware that she had gotten a personal protection order against him in Tuscola County. And I've reviewed the personal protection order. It gives her residence as her parents' address in Cairo, Michigan in Tuscola County. The plaintiff's complaint is entitled a complaint for separation, custody, and parenting time, but in review of the complaint, it does not ask for any relief other than custody and parenting time, not even child support. So for that reason, it's a complaint for custody, and therefore the complaint for custody should have been filed where the minor child resides, which at this point and at the time of filing, more importantly, was Tuscola County and still is Tuscola County. My client has no intention of returning to Calhoun County. Certainly, she has no intention of getting back together with the plaintiff. If she had, she wouldn't have gotten the personal protection order against him out of fear for her and her family's safety.
Okay. Mr. Schaefer, what's your response to the?
My response to that, Your Honor, is that the child was born September 19th. She left on the 22nd with her parents under a situation where she is going through extreme depression. As set forth in my brief, she had been fighting depression for some period of time. She'd been treating in Calhoun County since 2018. She had postpartum depression. She left. Her parents came down, picked her up. She had lived along with the child in Marshall since they got married and before they got married, and they got married in 21. So her residence was here. The fact that she went out of the county with her parents doesn't mean that she has set up a residence elsewhere. Everything that she has, license, reference to where she lived is Calhoun County. It's a forum shopping problem for the venue, that somebody runs out of county 2.5 hours away and files for divorce or in that county. It's a forum shopping. It makes it inconvenient. Everything is in Calhoun County. She's lived here. She was living here at the time, along with the child was living here, and the residence of the child was here when my client filed. And he filed. Why did he file? Because the mother was keeping the child from him. He wanted to see his daughter. He has not seen the daughter since September 22. Because a PPO is there, he is not able to reach out. And so he had no alternative but to file for a custody matter here in the county where everybody resided. To go to Tuscola County, 2.5 hours away, and say, oh, this is where the child resides. There's no indication that this she has set up a household there or intends to. As indicated in my brief, on the 24th of September, they talked for 6 hours on a Sunday. And there was talk of reconciliation, of counseling for everybody in an effort to save this marriage. And that is what my client wishes to do, is to save the marriage. But he is hamstrung now because of the PPO. I think the jurisdiction is proper here in Calhoun County. We are asking that there be some sort of temporary order so he can see his daughter. He has not been able to see. It can be supervised. His father is Robert Nichols, an attorney in Calhoun County, lives in Marshall. He is willing to supervise if that is a concern. And we, in the pleadings, they say, well, he ought to get a psychological evaluation. He has done so already. Summit Point on October 11th, he went and got a psychological report. And they blame him for the mental illness, but the wife had the motor tic from high school. It's a hereditary thing. Her father also has Tourette's syndrome. So placing all the blame on him, I don't think is appropriate. My client is willing to participate in whatever counseling there is, whatever evaluations are necessary, whatever supervision is necessary. He needs to have some contact with his daughter. He realized she's young, and the child is nursing at the moment. So we understand that those are impediments for long-term parenting time, but he needs to have some temporary time with his daughter. I think the venue is here. I think the actual venue is here. And to the other venue statute is that you need to file where the defendant resides. In our position is that the defendant mother did reside in Calhoun County at the time, but apparently contrary to that, they go to Tuscola and they start a divorce action there that I'm aware of, but has not been served yet. And I don't think that's proper service because the defendant is in Calhoun County. They didn't file here, and Funk v. Funk seems to indicate that if that statute doesn't apply, then this forum shopping that is going on. And I think that's what's happened here. We're asking for relief, Your Honor, that the court determined this is the proper venue. We pre-filed here, filed before they did for the custody when the child, in fact, was the resident of this county. She had not established residence elsewhere, and I'm asking that the custody or the parenting time motion be heard here.
Okay, thank you.
Your Honor, may I respond briefly?
Yes, go ahead.
My client is in the process of switching out her license address and things like that to show that her new residence is with her parents in Caro. To say that she hasn't established a household there, that is simply false. She is, as with many people who are going through a divorce or separated, she's living with her parents right now, as many people do in these situations. They did not talk for 6 hours on September the 24th. They spoke for approximately 2, but at no point did my client lead the defendant to the plaintiff, to believe that she was getting back together, or that their marriage could somehow be saved. And again, the simple fact that she got a personal protection order shows that she has no intention of coming back. So for
What's
that
your
reason,
response for parenting time, Mr. Umlauf?
we would request supervised parenting time if the court is going to keep jurisdiction here. I do not think the plaintiff's father would be an appropriate supervisor. We would request a professional supervisor through Family and Children's Services instead.
Okay. You don't think as a attorney and officer of the court that he'd be able to be a supervisor?
Unfortunately, Your Honor, this case is extremely emotional and difficult for all parties involved. But based on the pattern of abuse by the plaintiff and my concerns, and my client's legitimate concerns based on his threats that he would cause harm to her family and to her, and she's concerned also that he may harm the child. For that reason, I think a professional would be best.
Okay.
Family and Children's Services are a similar entity.
Okay, thank you. Well, what I'm going to do in this matter, as I stated in this case at the start, is that plaintiff had filed in this matter 7 days prior to the defendant filing. She had went with her parents, but as stated by Mr. Umlauf, she's in the process of changing her residence. Well, she hadn't changed at the time that the action was filed in this matter. So the court is going to determine that Calhoun County is the proper venue in this matter. I'll deny the motion for change of venue, and we'll let the matter proceed in Calhoun County. The plaintiff has already had the psychological report from Summit Point. We'll order that he, in fact, provide that to Mr. Umlauf's office. The court is going to, in the interim, is going to grant parenting time 2 times per week for 1 hour, supervised by the plaintiff's father. If the parties cannot agree on the time and date, it'll be Monday and Thursday evening at 7:00 p.m. for 1 hour. And the child will be delivered to the father's home so that that can take place. Anything else, Mr. Schaefer?
No, I will prepare that order, Your Honor. Thank you.
Mr. Umlauf, anything else?
Yes, Your Honor. The one thing that wasn't mentioned was child support.
What I'll do is I'll order support pursuant to the child support formula. I'll allow the parties to exchange income information, and the attorneys can calculate that support amount.
And Your Honor,
Thank you, Your Honor.
I do have one other question. Could we
Sure.
do the supervised parenting time at a place that's closer to where the minor child is living at this point in time? It would be about 3 hours, I believe, to transport the child from where he is currently living to the plaintiff's home.
I'll have it in the father's home because again, he's the supervisor. I don't want to inconvenience him any more than already necessary. So we'll have it take place in his home.
In plaintiff's father's home?
Plaintiff's father's home, yes.
Understood.
Okay, Mr. Schaefer, you can prepare that order and submit under 7 days.
Okay, very good. Thank you.
Thank you. You got free to go
Well,
at
no, to appearance, Mr.
9:34
Toth. Have a
on
good
behalf
day.
of plaintiff. I see that defendant has attorney. I'm not familiar. Would you identify yourself, please?
Absolutely, Your Honor. Good morning, Attorney Nicole Samuel on behalf of the defendant, in this case, Bethany. And actually, her last name is now Christensen.
Okay, well, it'll go down at the whatever it is at the time of filing is what they again they call the case. So
No problem.
notwithstanding, it'll proceed at least for on the court's file for under that name. This matter is before the court on the plaintiff's motion for order suspending defendant's parenting time, motion for change in custody and support. Mr. Toth.
Thank you very much, Your Honor. The heart of this motion has to do with the not only the well-being of 11-year-old Ellie, or soon to be 11-year-old Ellie, but her safety. Your Honor, I think that taking the 10,000-foot view, I think the facts that have been alleged and even the admissions that have been included in the answer certainly indicate that we have identified facts that would authorize moving forward to a custody hearing. We have certainly identified good cause as well as a material change of circumstance if the facts are proven true that would warrant a hearing in this matter. So that's the broad view. And as we take a closer look at things, Your Honor, and it has to do with the suspension of parenting time, with all due respect, I would say that the verified answer in this case really raises as many questions as it answers. I think it's absolutely been acknowledged by the defendant in this case that there are mental health issues that are ongoing, and they're really extraordinary. I would point to the admission that was made on page 3 of the answer, paragraph 7C, where there's a candid admit that defendant threatened suicide on September 7, 2023. Defendant is not suicidal. Those two sentences, Your Honor, are absolutely contradictory. You don't, if you've threatened suicide, then to suggest I'm not suicidal, I'm not sure that that's logical, makes sense, and it certainly warrants gathering more facts and investigation in order to determine whether or not that you can both threaten suicide and in the next breath say I'm not suicidal. In the defendant's petition to terminate the PPO, which has been recently filed, and I would say, Your Honor, that PPO I think is in effect, and I would suggest the fact that the defendant's apparently now residing with their husband violates that PPO. The defendant's statement is, I have been experiencing some overwhelming mental health challenges that have led me to make irrational decisions. And she goes on to say, I have started my journey by seeking help. So again, an admission of overwhelming mental health challenges and making irrational decisions. Your Honor, with all due respect, it would be my position until such time as we can have a hearing, that we can have a psychological evaluation conducted, that we can gather some evidence through discovery. I think the allegations that we've made and even some of the answers that have been acknowledged, I think that there is clearly a safety risk here. This isn't, again, you can't be threatened suicide and say I'm not suicidal. That's just not fair to conclude that there's not an issue because I say there isn't one. So, Your Honor, I would respectfully suggest that the suspension of the parenting time continue until such time as we can do some at least initial discovery and have the matter scheduled for an evidentiary hearing, not only on parenting time, but also on the much broader issue of a change of custody, as well as an alteration of the long-term parenting time schedule. Thank you.
Thank you. Ms. Samuels?
Thank you, Your Honor. Obviously, we're here today, and I think the main thing that I want to address is the fact that obviously there has been a suspension of parenting time. A hearing was supposed to be scheduled. It wasn't. I ended up scheduling it with the court to get mom in front of the court to address the suspension in parenting time. She's already missed 2 weeks of parenting time with the child. This child has been going back and forth, week on, week off, between her two parents since she was 2 years old when the parties separated. She's now about to turn 11, I believe, on Friday. So this is a major impact on the minor child as well, which I think needs to be in the forefront of everyone's minds. I think that there's some steps that we could take to alleviate some of the concerns here that dad has. One, mom has already done a psychological evaluation. She did so in her own accord. I indicated I would be happy to disclose that to plaintiff's counsel. However, I would ask this court for a protective order just so that, her psychological evaluation isn't just given to the parties or anybody else. But she's happy to disclose that her diagnoses were not super severe. She was diagnosed with generalized anxiety, depression, and PTSD from some past traumas. It was recommended that she start therapy and see a psychiatrist to discuss exploration of medication. Both of these things she has done. She has started going to therapy once a week. She started therapy on the 9th of this month. She also started seeing a psychiatrist, and she has since started taking an antidepressant. All of these things happened after that. The therapy and the medication started happening after the September 7th date where she threatened suicide. She is not suicidal. The threat of suicide happened, it was a moment of weakness. She was going through a divorce at that time with her husband. And since, as I indicated, she has taken steps to make sure her mental health is under control. You know, on top of that, the PPO, there is, as Mr. Talk indicated, there is a motion to terminate the PPO. It's scheduled for this Wednesday. So that should be resolved on Wednesday, one way or the other. Mr. Snyder actually did a welfare check of the child when the child was at mom's home with the husband present when the PPO was in place. The police decided that the minor child was not in danger, did not take the minor child from the home, did not arrest Ms. Christensen's husband, indicating that he was in violation of the PPO because the officer understood that there was a motion to terminate the same and that mom was not in danger. All of that has also been alleged in the motion. So, you know, the police has also indicated that the minor child wasn't in danger when they arrived at that home. You know, there's a lot of allegations that there's physical abuse happening in this home. There's not. Neither party's ever been arrested. There's no domestic violence history. There's no criminal history at all. Mom is not utilizing drugs. There's no drug use. She takes prescription Adderall, and she takes it as prescribed. Other than that, she does not use drugs in any way, shape, or form, and she's happy to take a drug test. If this court wants to order a drug test for her, she will take one at any time.
Ms. Samuels, Mr. Toth had alleged that at the time she was hospitalized, she did have methamphetamine and ecstasy in her system. Are you saying that's incorrect?
The methamphetamines in her system, methamphetamines and amphetamines are tested the same. I have the drug test. It says methamphetamine / amphetamines. That's the Adderall in her system. The ecstasy in her system, as I'm sure this court saw in my response, she was drugged. A date rape drug was put in her drink. And that is the ecstasy that was found in her system.
Okay, anything else?
I don't believe that this child is in danger in mom's care. I think that the well-being of the child not seeing her mom at all, especially when I have to imagine an evidentiary hearing is probably not going to be scheduled in a week or two. So to keep this child from her mother when officers have been at the home and don't believe that there's a danger and mom has taken steps to make sure her mental health is in check, I don't believe that keeping the suspension of parenting time is appropriate.
Okay, thank you. Well, I'll tell you, just so you know, I don't rely upon, again, hearsay or any inferences from that any police officer might say when they're on the scene for a limited period of time. So that is not persuasive in any way. What the court will note in this particular matter is that most recently, there was a recent case released, Beretta versus Sitkoff. It was released on October 12, 2023, released for publication, but we don't have any citation yet. And that case happens to go through and set forth the law and the standard for suspension of parenting time. And it states that parenting time can be suspended where, again, the evidence shows that it would have an impact and endanger the child's physical, mental, or emotional health. In this particular matter, I think based upon the allegations that are not disputed, that she did in fact threaten suicide, that there is sufficient evidence as to the answers as well, that she has some substantial emotional and mental health issues. So the court does believe that pursuant to the Beretta case, that there is a basis to, again, establish that it would impact and affect the child's physical, mental, or emotional health. So the court is going to continue the suspension of parenting time with some provisions. The court does note that as well, there's proper cause and change in circumstances to meet the Vadvarka threshold to proceed in this matter for change in custody. So the court will have an order of hearing. We'll contact both attorneys' offices and see when we're able to schedule that. But it does appear that based upon what's been said, that you're going to need some period of discovery. The court would order that the defendant would release the psychological evaluation as well as any other reports that come up in this matter to Mr. Toth, and that the court will also order that that be through a protective order, so there'd be no dissemination to the parties or any other individuals other than Mr. Toth himself or anybody working in his office in this on this particular matter. The court would, in the interim, award to the defendant some supervised parenting time. If a period of time of 3 hours per week on Saturday from noon to 3 o'clock, the court would order that the plaintiff would provide 3 names of supervisors within 7 days of today's date, and the defendant then has 7 days to choose which of those individuals would supervise the parenting time, and after her designation of that, then the matter would proceed on that following Saturday. So I'm assuming it won't be this Saturday, but the following Saturday appears that that would work for starting the parenting time. With that, I'll ask Mr. Toth that you would prepare the order in this particular matter and submit under 7-day notice of entry. And looks like that concludes this matter at 9:49 a.m. Anything else, Mr. Toth?
No, Your Honor.
Okay. Ms. Samuel?
No, Your Honor.
Okay, thank you.
2023
Have a good day.
at 10:31
Thank you, Your
a.m.
Good morning to both of you.
Good morning.
Court will note that this matter is before the court on the defendant's motion to set aside default. Mr. McKenzie, what is your basis?
I didn't, it's first time having a divorce, so I didn't know anything about the logistics of it. And I wanted to argue about the property that we obtained, the stuff that, I feel fair that we split. We have 20 some years together, all together, before marriage and everything. And we accumulated quite a bit. But all I'm asking for at this point is just the property that belongs to the trailer that's in my name, that she put in her name prior to me being locked up.
Okay.
So, and I'm telling her she can keep everything else. I just need the property so I can get it back up to par. That way she'll have a house, I'll have a place. Everything should be, then other than that, I'm just trying to keep it simple. That way I can get back into my house.
Okay. Ms. McKenzie, what's your reply?
So I bought the trailer when Jordan was in prison from my uncle, and I paid for it. Jordan barely worked the whole 22 years we were together. So everything that was accumulated, I paid for because I've been working for the last 22 years. And so I just feel like the property, like he just feels like he's entitled to everything. And I feel like because he didn't, we have a long history of domestic violence. We have a history. He has 2 other kids that he's had since we've been married. And I just feel like I just want out of this. I just want a divorce and be done. And I don't feel like he's entitled to anything that I've had to pay for working my tail off all them years.
Okay.
Your Honor,
Go ahead.
I'd like to add to that, I put all the hard work in of remodeling both houses. I put time and money in. I did work. just because I didn't work as much and consistent as she did. But I did a lot of specialty jobs, like work for Future Environmental, seasonal work, stuff like that. So I made good money, and I put a lot of my money and time, sweat, and equity, and tears, blood, sweat, and tears into fixing houses up so I'd have good homes for my children. And the one was supposed to be a rental property, which I would like to get back and turn it into the rental property so I can start saving money for my kids' education. That's the whole point of me starting to, the only reason I told her to buy the property in the first place, because she consulted with me and asked me if she should buy it, if I would do the work. And I said, yes, I would. And so I put time, effort, and everything into it. And every time something happened, she would put me out. She'd actually put a PPO on me, had me put in jail, and then put the property in her and her sister's name. So I couldn't.
This isn't germane to the issue that the court has to decide, so I don't really care about the PPO.
Okay, but other than that, that's but the property was put in her sister's name during the time that we was split apart, when it shouldn't have been put in nobody's name but our name, is what I'm trying to get at. But her sister just recently passed away, so now it's back in her name. So,
okay,
I just think that it'd be fair. If not, I told her I tried to contact her and talk to her just about the property and stuff that we have, and see if we could come up with a conclusion of being grown and do it the right way. Be grown and come with the just to get with this whole ordeal behind us and get ahead with our lives. And I just asked about the property that the trailer's on. She can keep everything else. I just want the property that the trailer's on. That way I can get help. I can't do nothing with the property not being in my name. We get financial help to get stuff back up to par. So
thank you, sir. Thank you. Well, in these particular matters, what the court can't just do it because a party requests. Obviously, when a party seeks to set aside the default, they have to come in with good cause, and good cause is established by case law, etc. You had alleged that you wanted to, again, set it aside on the basis of your paragraph 2.b, but your 2.b does not allege any good cause. So the court cannot, based upon what you filed at this point, the court cannot grant your motion. And as a result, I am going to deny the motion at this time. That will conclude this matter at 10:36 a.m. You're free to go. Have a good day.
Yep.
Thank you.
Thank you.
So what happens at this point, sir?
Well, the case is over at this point, and unless you file something else or file appropriate pleadings.
Okay. So as far as the divorce, it's over, or
Not at this point. It's not over until we take our final pro confesso hearing and complete it at that time.
okay. So I thank you, sir. I appreciate it.
Okay, thank you.
9 a.m.
Yeah, bye.
Good morning to both of you. Court will note that this matter is before the court on the defendant's motion for dismissal for lack of subject matter jurisdiction and the defendant's motion for dismissal of the default. Ms. Platabos, did you receive the motions?
Yes, I received the motions on the last Saturday, and me and legal services are asking for an adjournment today, just because.
Okay.
Sorry.
Okay. Sir, what'll happen is they've asked for an adjournment so she can get representation. In those instances, the court will grant the motion. So we'll adjourn the matter for 2 weeks, and then we'll be back in 2 weeks. We'll deal with the motion at that time. Okay, sir?
All right.
So just same number, join the same way, and then we'll get the matter heard then.
All right. Thank you.
Okay, thank you. You're free to go. Have a good day. I know not sure. Good morning to everyone. The court.
Good morning.
the appearance of Mr. Smith on behalf of the petitioner, Mr. Wickwire, and Mr. Schaefer on behalf of the respondent, Ms. Leatherman. I would note, just for the record, that the court had reviewed the testimony from the previous hearing commenced on August 21st, 2023, and then continued on September 27, 2023. So I've reviewed all that. And the reason for that is I didn't want everyone to just reiterate the testimony that occurred at that time. Court will take judicial notice of that in this particular matter. Anything, Mr. Smith, preliminarily before we commence?
I guess being that the court has already reviewed the testimony, the idea that we were here was actually something that was mentioned by the court during that hearing, and nothing other than to mention that, nothing further.
Okay, Mr. Schaefer, anything preliminarily before we commence?
Well, the only preliminary thing is what I put in my pleadings, Your Honor, that I feel that probably 90% of the allegations are irrelevant to a PPO when they're talking about the prior litigation and the prior allegations concerning the inheritance or the lack thereof, the cooperation. I don't think is a PPO issue. There's very little PPO issue. It appears to be retaliation against what happened at a prior PPO hearing. I don't think there's a basis, even if true, for a PPO. So I would move at this point in time that the petition be dismissed.
Okay. Mr. Smith, any response?
Yes, Your Honor. I don't have anything that Mr. Schaefer has submitted, so I guess I would defer to my client on whether we should request an adjournment so I can review those, or we could just proceed with what I have in front of me, which is his statements. I'm kind of getting in at the last second here.
Okay. Getting a little noise here. Hold on. Okay. Any response to that, Mr. Wickwire?
I guess I'd want to talk to my lawyer.
Rusty, either we can go, I apologize, Your Honor. Rusty, either we can go ahead right now, or we can request an adjournment so I can review Mr. Schaefer's responses and then plan accordingly.
I guess I was not aware that Mr. Smith had filed an appearance. I hadn't received an appearance on this, so this is news to me also.
We just did today, and if my assistant did not send it to you, I apologize.
All right.
Okay. Well, what are the thoughts?
I guess my preference would be to adjourn so I can see exactly what the defense would be saying. I don't have that.
Okay. Mr. Schaefer, what's your thoughts on that?
Well, my thoughts are that if it's going to go forward, it's going to be a long, drawn out hearing. I mean, the allegations here are, I didn't count them, 20 or more. And so an adjournment might be appropriate in a longer period of time. I don't know how much time the court had scheduled this morning for it.
Well, I scheduled until we're done, but it'd probably be better if we did adjourn. Why don't we do this? The court will adjourn the matter to November 6th, 2023 at 11 o'clock. Does that work in your schedule, Mr. Smith and Mr. Schaefer?
May I have a moment to check?
Sure, it doesn't take that long considering what you've already heard.
Well, I'm hoping to. That's why I reviewed it, so that hopefully I could eliminate a lot of testimony. Would you check and see if you're available on November 8th?
November 8th? Hang on.
Mr. Smith is, so.
On the 8th, Judge, I am free in the afternoon, available. I've got an 8:30 in the morning and 11 o'clock.
Okay, let's do this. Let's adjourn it to November 8, 2023 at 1:30 p.m. and we'll proceed at that time.
Very good. Mr. Smith, if you forward your appearance, I will forward back my answer so you'll have it.
We'll do that immediately. Thank you.
Okay.
Okay, thank you.
Thank you all, and your excuse. Have